as usual, this Saturday, good morning to everyone.
Good morning.
From Mehta and myself. Today's topic is directors' appointment powers, rights, duties, and responsibility. It's a long topic. As Shailesh Bhai today said, it will not happen in one session. Let's see, we'll try our best. Because on this time we have decided that we will take all questions at the time of presentation. So any participants can raise any question during the period, and we will offer it to panel and expert panel, and even any participant can share the experience. Please, this is a discussion. It's a knowledge sharing session. Any participant can unmute and talk, but I request all participants to take care of unmuting yourself as soon as your talk is over. That will be helpful and it will not disturb the others. And thanks, friends. Let's start. I welcome today's our two expert friends, CS friends, very senior friends of me. First is Mr. Umesh Ved, my very old friend, Maya Natuls, and we share a very good relation since years, since our young age. A practicing company secretary from Ahmedabad. He's practicing since more than 2 decades, friends. He's a fellow member of ICSI and also lawyer. He's a proprietor of Umesh Ved and Associate, a leading practicing company secretary firm of Western India, specialized in merger, amalgamation, takeover, IBC, security law. He himself is also IP, foreign pharma, and other value-added services to corporate clients in the field of legal compliance and appearance before quasi-judicial bodies. Welcome, Umesh Bhai, to today's session, and we'll really look for your expert and comments.
Thank you, Dipti-ben. Thank you very much.
I will introduce my another very old friend, Sanjay Rachi. I have experienced his knowledge in all fields like anything since years. His knowledge in FEMA, NBFC, company law, excellent. And we welcome Sanjay Rachi. He is a company secretary and law graduate by qualification, having overall business and management exposure by experience. 30 years of post-qualification experience, having blend of industry and consultancy. He was earlier practicing CS, so I know him very well, and had varied exposure in the field of corporate law, including FBI, finance, project management, and administration. Welcome, Sanjay Bhai. Sanjay Bhai has joined. Mr. Sanjay? I think, Nitu, as soon as he joins, please let us. We will start.
Yes, ma'am.
Okay, thank you. Okay, Khushi, and today's presenter is Ms. Khushi Jain and Mr. Sumit Bave. As you all know, they are both are our intern, and as usual, our practice of Mehta and Mehta, our intern are our future CS, and they should be having a quality of Mehta and Mehta. And today they are presenter. Yes, over to Khushi, and sorry. Before that, I will like to introduce, of course, no need introduction, our own Mr. Bala, the great degree holder, and of course, Shailesh Bhai. And I will request on the topic, the directors. Today, I think I don't need its introduction to be given. I will tell Mr. Bala to speak on the topic on 2 minutes, and then Umesh Bhai, and if Shailesh, Sanjay has joined, then he will talk on 2 minutes. Over to Mr. Bala, please.
Good morning to everybody. I think since all the participants will be knowing about the company directors, this doesn't need any introduction at all. But the only thing is the directors are the people who are actually managing the day-to-day affairs of the company. At the end of the year, they actually report to the shareholders of the company what has happened in the last year, like we get a progress report in the schools. So by way of the board report, they actually inform everything to the shareholders, what all has happened, what they have done, and also future prospects, what is the threats, what is the opportunity, etc., which are available. But in the course of the discharging their duties, they are governed with the company's articles, which have been approved by the shareholders. They are allowed to act within that power and also within the Companies Act, within the secretarial standard mandatory requirements. If any non-compliances which has happened, they are all responsible for liability. And if they exercise in excess of the power, then again, you all know it goes to the ultra vires, etc. So all the necessary care are required to be taken by the directors. They hold the largest responsibility, and it is a very, very complex position in exercising the skill, diligence, especially compared to independent directors today. I think our participants are going to take us through the various procedure regarding appointment and the power and the rights, what they have, duties and responsibilities. Let us hear from them. And I think they will also present some of the decided case laws in this respect to enlighten the audience. Any panelist would like to add anything on this?
Yeah, Dipti Ben, if permitted, I would like to share that this topic, the directors itself, is such a topic which has been into the limelight in last 2-3 years, or rather a decade or so. I recollect the role of a directors in Satyam, or the spate in between the Tatas. These are all into the public domain. So I'm naming that companies, that there was a dispute between Vadia and Mr. Ratan Tata because of Cyrus Mistry. There were the cases of the promoter directors who did fraud into the Fortis hospitals and Ranbaxy, and all that is into public domain. In Infosys also, there was a dispute in between the directors. The CEO was to Vikas Sikka, or he was required to be sacked out. And there were the disputes, and there were some public comments made by the independent directors also with regard to functioning. And the latest being PTC India Financial Services, wherein the independent directors, out of the governance issues, have tendered their resignations from the board of the company. So basically, this is such a topic which is of varied interest, wherein we, the company secretaries, at time and often getting involved directly, indirectly, whether we want to get involved or we don't want to get involved. But if we don't have a choice, but we have to get involved on either side. So this is the right topic chosen by Mehta and Mehta to be deliberated upon. And I'm sure that at the end of the session, the participants would be enriched with some of the new insights to face the challenges in the times to come. Thank you.
Thank you, Umesh Bhai.
Umesh, Dipti, just first of all, good morning to all, and
morning, Sanjay.
Morning, Sanjay. Yeah.
I just want to add to what Umesh ji just said. Incidentally, you really see the participation, or the what we should say, the real participation from independent director during such times only, when there are some issues either inter se among the directors or on the company. And at that point of time, the responsibility of the company secretary would be really very crucial, because he has to ensure that he is creating a very good bridge between all internal directors as well as with independent directors, and advising that all of them in a proper and legal compliant manner, and ensuring that all documents which are getting recorded are also done in a proper manner. That's very critical thing, which we will really not find in any of the rule books, but that's the call which company secretary will have to take at that point of time.
Very well said, Sanjay. Because last week we had minutes as a topic, and as we all CS has experienced how it's crucial. And that minutes we specifically has to take care when the directors are there. If there is any dispute, difference on any topic, it is CS who will come into picture. I was not given notice, I was not given agenda, I was not allowed to speak, you are not written properly. Everything this, even though there is two directors at a fight, and it is CS who has to come in picture. So like I always give one example. In one of our client, I was in a board meeting and there was a compliance issue. And I said that yes, you have to do this action and it is required. And but the promoter was not taking that action, that management. And then in the board meeting, that CS told that they are not listening. I said, say openly now, you have no choice, because C was also officer in default. And then C spoken. I said, don't worry, you say. And then independent director was, telling that CS only, you should have taken care and all that. So she was looking at me, I said, keep quiet, I made it. And when the meeting is over, I said, they can't tell directly because they share the repo, but they convey the message that boss, we will not accept this non-compliance, complete it. So this is the way actually CS should understand that what the directors are telling. And this really helps, and honestly, she never lost the job, whether she was promoted thereafter. Because independent director also realized that CS is really impartial. So adding that, fine, I think today's topic has a lot of discussion also. So I'll request the presenter, Ms. Kushi and Sumit, to start their presentation, please.
Good morning, everyone. Hello, I'm audible?
Yeah, very much.
Yeah.
Good morning, everyone.
Good morning.
Myself Sumit Dave, CS Management Training at Mehta & Mehta. I also have with me Ms. Kushi Jain. So the topic for today's session is regarding directors and his roles and responsibilities, duties and types of committees, which is mandatory for the companies. So with all your due permission, can I start the presentation?
Yes, please go ahead.
So as you all know that company being an artificial legal person cannot make decisions on its own. And for effective running of the company, various stakeholders are necessary like employees, vendors, government, shareholders, directors, outsiders, customers. But considering all these stakeholders, we can say that there are two main pillars of the company. That is, first is shareholders and the second is directors. These two shareholders and directors are very much responsible for effective running of the company. So as we all know that director is a person who is liable for conducting day-to-day business operations and also make policies and make other stakeholders to perform according to the same. Director is responsible for management of the company. The definition of the director has been mentioned in section 2, section 34 of the Companies Act 2013. It states that director means a person appointed by the board of directors. So the next term is in mind regarding the board of directors. So the collective body of the directors are termed as board of directors. Works may count out of the. They are also referred with the other name of the board like board of governance, board of managers, board of trustee, and etc. Just wait.
Yeah, it should be earlier slide. Yeah.
Sumit, you are on mute.
Hello, I'm audible?
Yeah.
Yes.
Yes. So as you can see on this slide that types of directors. So for the effective board, various types of directors are appointed on the board. These duties, their duties and functions are also different. So broadly, we have covered 10 types of directors. This is just a summary of the types of directors. In future slides, we are going to explain about each type of the directors in detail. So the types of directors are, we can see that executive directors, non-executive directors, managing director, residential director, small shareholder directors, women director, additional director, alternate directors, nominee director. So they are the board types of the directors in the board. Moving forward to the next slide. So let's first talk about the women director. In today's world, as we all know, aware of the world is promoting the women empowerment. So this also creates an impact towards the gender equality and increase the female representation at the board level. So to increase the involvement of the women in corporate governance, and the government has made provision regarding the women director. So this will create a balance on the board. There are particular types of companies who are mandatorily required to appoint a woman director on the board. They are as follows, like every listed company, every public company having paid up share capital of 100 crores or turnover of 300 crores. If the company falls in below mentioned criteria, then such company is required to appoint at least one woman director on the board. The appointment of woman director is done through normal process only. Also, if the position of the woman director has become vacant due to unavoidable reasons, then the vacancy need to be filed within 3 months from the date of vacancy or in the next board meeting. Moving forward to the next slide.
Now, in this woman director, actually, if there was a comment that generally it is always their relative, the promoter relative happens and not kind of outside and all that. So we had a discussion once and I actually observed that. I said that whatever may be, woman is woman, whether this family, that family. And in certain places with this woman who are housewife, they become active and they really become partner and they started taking action. So I have actually seen that even though it is that, many criticize that you are taking only the family member who are housewife and all that as a woman director. So purpose is not achieving. Rather, I feel that that purpose is getting achieving. The lady who was in housewife, not knowing the business, really takes part actively in the interest of the business and she is contributing to the business. Of course, Cafe Coffee Day is there. She herself was very much good in her knowledge and experience. But in other places where the lady were housewife and become director because of this requirement, and now she is so much active, and I see in a big business houses, ladies becoming director and they become a very active part in CSR activity and CSR committee. So I look at that even though, because always there is always argument whether woman director should be from promoter family or not, it serves the purpose. According to me, it serves the purpose. What's your view, Mr. Bala?
Even in many companies, we see actually the women director. No, in fact, ICICI was headed by the women director who was the chairman. And even the Axis Bank was headed by the women chairman. Even SBI was headed by the women chairman. There are a lot of things out there. And not only that, as you rightly say, I have seen in many of the big business houses, they employ a women director who are actually council members, who are actually practicing the law, etc., to their better contribution in terms of the running the compliances, etc. There is a tremendous contribution is actually coming from the women directors. Actually, we increasingly see the women participating in the business of the companies. That is true. As you rightly say, whether it is relative or non-relative, when they are given the responsibility, they perform very well. In fact, everything starts from the house. You tell me one thing, Dipti, when I come to your house, did you anytime say that I am running short of something, I can't give you coffee, tea, I can't give you anything? Everything is there. You are managing in such a way, everything is put in place, stock is put in place, reorder level is maintained, ordering level is maintained, minimum stock is maintained, everything is done at your level. The same thing you are putting in the practice when it comes to the business. My hats up to people, women who actually manages from the house, which actually when it transfers to the business, they can tremendously contribute to anything. I have seen it myself.
So it's a compliment from Mr. Bala to all women here, huh?
Yeah, 100%. I'm very much, appreciating the women, 100%.
I think we all would not mind seconding that.
Hold their hands. I really hats up to all the women.
Yeah, thank you.
We don't, Sanjay bhai, we don't have an option to disagree also.
Very correct.
Let it be.
Yeah. Okay. Carry on presentation, please. Yeah. Please start the presentation.
Yes, ma'am. Moving to the last slide. So in this slide, we are talking about recent statistics with respect to women director. So in this slide, as we can see that in 2015, there were approximately 4.11% of participation of the women director in the board, whereas as compared to 2021, there is 17.13%, which is increased by 4 to 5% in the women directors. So that's a great news for the same. But as comparison to the other companies, like as we can see that growth of women directors over the world. So in India, the growth is 17.30% as of now, but in other countries is 20%. So yet we are lacking behind. India ranks in 12th position of the same representation of women director on the board. So this is a graphical representation of the women director.
Okay, there is a question in the chat box that all three requirements are to be fulfilled for a woman director.
No, ma'am. It's or.
Or. Okay,
it is this or that, any one of the conditions, not all the three conditions simultaneously.
Okay. Next.
Okay. Moving further to the next slide. Now talking about different types of directors regarding independent director. So as we can clearly identify the purpose of appointing this type of directors. through name only. Independent directors are those who do not have any relation with the company by any means. They are purely independent towards the company. To see that the person is really independent towards the company, only needs to find a definition of the independent director. The definition has been mentioned under section 149, subsection 6 of the Companies Act 2013. Is speaking in brief, independent director is a person who is not associated with the company by any means. Like women director or few companies are appointed by independent director is mandatory. They are every public company having paid up share capital of 10 crores or more, or every public company having turnover of 100 crores or more, or every company having outstanding loans and deposits of more than 50 crores or. So if the company falls in above mentioned criteria, then such company is required to appoint an independent director. Every listed company is required to appoint at least 1/3 of the total number of directors as independent director. Also, if the chairman of the company is executive director, then there must be at least half of the board shall be independent director. So this is all about independent director. Also, as per the recent amendment with respect to independent director, the appointment of independent director in previous section has been done through ordinary resolution, was sufficient. But pursuant to the amendment in the same, the appointment is mandatory. The appointment is required done through special resolution. So there is a case law which Umesh sir has told regarding PTC India Financial Services. The independent director of the PTC India Financial has resigned. All the 3 independent directors have resigned over the corporate governance issues and matters. So that was a case regarding the independent director. As the board of directors were ultra virus, which result. Hello.
Yeah, we can hear you. Go ahead.
Okay. So the board was ultra virus to the resulted all the this regarding inform, but the board blindly ignored what the independent director were trying to say, and due to this, all 3 independent directors resigned from their office.
Sumit, keep little mic away. Your voice is little breaking.
Okay, ma'am. Sure. Moving forward to the next slide. Another type of director is resident director. A director who stays in India for more than 180 days is termed as resident director. Suppose a foreign individual has promoted a company and both the directors are foreign resident, then they need to appoint at least one resident director. So during this COVID scenario, no one was able to travel freely, and due to some unavoidable reasons, the person, if stayed in India for less than 1 or 2 days, then this will not amount to non-compliance for financial year 2021, as per the circular issued for the financial year 2020-2021. This was circular issued by the MCA. Another type of director is nominee director. So basically nominee director is a person appointed by lending institution on the board of directors by the borrower person. The reason for such appointment of the borrower person, the reason for such appointment is safeguarding the loan provided by the bank or lending institution. So the role of nominee director is restricted to safeguard the interest of the lending institution. Moving forward to the next type of director is about
Sumit.
Yes, sir.
Your voice is not clear and you are little bit fast. So
okay.
Go slow and your voice make it clear.
Okay, sure.
Keep your mouth away from mic and go slow.
Okay, ma'am.
And as far as the resident director is concerned, the number of days, which is 182 days, there has been a MCA circular which has been issued during these pandemic issues. If the company is not able to comply with 180 days due to the travel restriction, etc., and all the things, that will not be taken on the non-compliances. So that is actually there. A relaxation has been given by the MCA to the extent to the resident director who are situated outside and who are traveling, they are not able to make it 182 days.
Yeah, there are questions in chat box. As we discussed, we will take it parallelly. One question is that how you derive percentage of.
Yeah, somebody is asking what is the growth of the woman director? How did you get
it? How you derive? It is from a report. It is written Credit Suisse or something. It is written on the right hand side. If you bottom, you have not noticed.
Yes, ma'am. That report was issued by Credit Suisse Report Authority.
Yeah, it is source is written, friend.
Yes, ma'am.
As regards another question, from which date the term of an independent director is counted? Is it from the date of board meeting in which he is appointed as additional director, or from the date of general meeting in which he is appointed as independent director? Over to panel.
It should be from the date of board meeting. That is what I feel.
See, basically the term of independent director is a 5-year period. In case if we take it from the date of the general meeting, in fact, that term would go beyond 5-year period, because even if we consider that board meeting has happened one day prior to the general meeting, the term would become 1 year, 5-year, 1 day. So to fall in line with the requirement of the term, the tenure should be taken from the date of appointment in the board meeting. And when we are making appointment in the board meeting, that is subject to approval at the shareholders meeting. So effectively, the appointment is valid from the board meeting.
Absolutely, you are right. It is actually from the date of the board meeting only. Even in the preamble of the resolution, we actually say this gentleman is actually appointed as an independent director. But it is
Right.
because the procedural things makes it that at the time of the board meeting, we have to file only additional director. At the time of the general meeting, when it is regularized, he is already a director. Only thing is the nomenclature changed from additional director to the independent director.
Regular director.
So the same started actually from the board meeting only, because that 5 years term will be counted from the right from the day of the appointment.
Dipti Ben, I have a counter question to Sanjay Bhai and Bala sir. With regard to say, if I hold a board meeting, say in February, because after March, then if I appoint, I have to get it approval within 3 months. Now the LODR allows the appointment to be made within period of 6 months. If he is appointing, say he is vacating within 6 months, he can be made prior to this. Which would the date I would take him as an appointment date? Say appointment ceases, the 5 years period gets expired in April or May. Okay, now within as per LODR, I have to get it approved within period of 3 months. So if it is in April, I have to hold my EGM or AGM before July. Now, if I am appointing today, I don't need to call the general meeting within period of 3 months. Can I appoint him today, making effective from April 22, so that I can get his approval in the AGM to be held somewhere in September 22? This is my query, counter question.
Umesh Bhai, I understand that you are talking about the second term of appointment.
Yeah, second term of appointment, exactly.
So the best corporate practice would be to do that appointment in the general meeting, which is going to be held prior to the completion of the term. But in case if that is not possible, and if we are making appointment in a meeting which is prior to the completion of the term, we will have to take the next term from the date when the first term is getting completed.
Okay, got your point, Sanjay Bhai. But can I make appointment today so that, see, these corporates, very frankly, they try that to hold a general meeting is also an expensive event. So right. I don't want to hold my EGM or AGM within period of 3 months from the date of his appointment. If I'm and reappointment, appointment includes reappointment. So even if I reappoint a director in April, I have to hold the AGM as per LODR, latest LODR, within period of 3 months before July. Now my AGM would be held in September only. It won't be held in July. So to avoid all these things, the companies are resorting to appoint the independent, reappointing the independent director to be effective from April, but they are appointing today. Is it workable?
Sir, my experience with LODR is that they always go for the stricter compliances. So even if we are doing the appointment today, and that would hold good as far as the period is there till April. But the moment in April, the new LODR compliance is coming into effect, they will insist for you to complete a EGM if you are not holding AGM, either through an EGM or through the postal ballot within a period of 3 months from that period.
Correct. That will start from the April 22.
I go by your views, Sanjay Bhai. I also have, but these are the queries which are being posed by the corporates to avoid holding of general meetings frequently.
So I can put this question in that way. whether any director can be appointed, whether a board resolution or members resolution can be passed for appointment of director in specific date. That is the question of law. What is your answer?
Sorry, Dipti, can you repeat that?
So the question will be, if we put it, Umesh bhai, correct me if I'm wrong, that whether a board resolution or a members resolution can be passed for appointment of director in future specific date.
So you are passing resolution before the completion of the term and making appointment with effect from a future date.
Sanjay, let's put this as a question, that you are passing resolution today that a director will be, that we appoint this person as a director effective 2nd February 2022. Whether this resolution is valid or not, whether board or member, whatever it is.
It is valid.
It is valid, absolutely valid. Why
So
not?
Umesh bhai, answer to
100%.
your question. Umesh bhai,
Ah,
answer to your question. This was your basic question, right?
yeah, this was the basic question, that future date appointment can be
Yeah,
made.
it is valid. Very much it is valid.
Right.
Okay, okay,
We
okay,
have done that. We have already done that. At least if I recollect, we have done it 2-3 times in some of the
Right,
future
right.
group companies.
Even I have done it, so that's the only thing.
It is
Because
perfectly
it's not
valid.
prohibited. You have to, and that only Umesh bhai was asking that, unnecessary again we having a meeting in a span of 1 or 2 months. I will pass it today.
Yeah.
Okay. Next question. Mr. A has completed a first term of 5 years as independent director in a listed company. Further, as per latest circular, the appointment of independent director has to be done by shareholders approved by within 3 months from the appointment on board. The company does not want to conduct a postal ballot or separate meeting for reappointment of independent for second term due to financial crunch. Can the director resign now and be reappointed in ensuing AGM? Is there any issue if he is not on the board for 3-4 months after first term? And can we appoint him as an independent director for second term after 3-4 months gap? We have solved your question in this Umesh bhai's question only, right? The problem is yours only that you don't want to hold a meeting immediately, and that's why.
The only difference between the first situation and the current situation would be that for the intermittent period, he won't be a director. Assuming that his term expires on, say, 30th of April, and you are he resigns on that day, and he's reappointed, say, on 30th September or 1st of September. So for the intermittent period, he would neither be a director nor independent director. But he can always be opted for a second term after the
1st September.
broken period. That there is no such restriction that if a director has completed term and opted not to continue at that point of time, he cannot be reappointed.
Or otherwise, you continue and pass in advance for future.
Yeah.
As
So,
we discussed.
so there are 3 different options available. Either you appoint in a board meeting, in a general meeting prior to the completion of term of expiry of the first term. Second, you appoint him in a board meeting and complete a general meeting within a period of 3 months after 1st of April. Right now that restriction is not there, but after 1st April, surely that restriction would come in. Or third, take a break and then reappoint at the forthcoming general meeting.
But does that mean that if he is not appointed as an independent director for second term, he ceases also to be a director, because there are 2 separate forms which are filed for director and independent director. Like for example, a person may be appointed as a director, okay, and he is not an independent director at that point in time. After that, he becomes independent director due to change in some situation. Say for example, 2 brothers are on the board. One brother resigning, so they automatically the second brother becomes independent director. So does that mean that ceasing of not appointing independent director will also cease to be a director?
See, my understanding is little bit different. I would go with the opinion of other panel member on this. But when you are appointing a person as an independent director, you are appointing it for a fixed tenure. So the moment that tenure is over, he ceases to be an independent director and he ceases to be director as well.
Correct, both. That is right. Absolutely
then-
right. That the term is over, he loses the position, whatever it is, either independent director, including the director. Because by virtue of the director, he is the independent director.
It's really ticklish issue, but because by
So like-
virtue of director, he is independent director. So first he is director and then you decide he is independent or not independent director.
No, Dipti. See, when you are making his appointment for the first time in the board meeting, you are appointing with an intent to take approval in the general meeting to appoint him as an independent director.
Right.
So his office as independent director starts from the date of the board meeting itself. That's what in the very first question we have clarified that the tenure would start from the board meeting date itself.
Right.
So technically, a person who is being appointed, even if though
Right.
shareholders
From day
has
one, he
not
is
approved,
independent.
he's an independent director from the day one.
Right.
So does that mean that suppose for the first time itself the shareholder doesn't approve his appointment as an independent director, which is placed before the general meeting, he will cease to be director also? Shareholders have not approved a particular resolution appointing him as an ID, not as a director. There are two resolutions. One, additional director confirming as a director. There is a change in the designation or the position. The second resolution is for appointment as an independent director. Now, shareholders do not pass independent director resolution, but they give approval for appointment of his director. So does that mean that he will cease to be director immediately?
No, this is a peculiar case which you are putting a query. So in this case, he would continue to be a non-executive director. He won't be an independent director.
So that's fine. That is what the question is. Will he continue as a director? Like a classic example, if MD resigns as an MD, he will continue to be a director.
See,
Because his term is
MD position is a bit different. If you are putting a position of MD or executive director, that is a different position because you are giving executive powers to such person. So they even after their term of executive appointment is cancelled, they continue to be the director simpliciter as well. But in case of an independent director, that's coming by virtue of a specific a type of a director which we are proposing to appoint. And from that perspective, that person need to be approved as an independent director by the shareholders. If directors are okay with his appointment as a director but not as an independent director, then the term for which he has been appointed in the board meeting till the date of the AGM, we will continue to consider him as an independent director because till that time he was subject to the appointment as a shareholder. But because shareholders has not approved his appointment as an independent director, that status goes away. But as shareholders has approved his appointment as a regular director, he would continue to be only a non-executive director.
that is what the when we say if he is not appointed as an independent director, he will also cease to be a director. So there is little gray area, I feel.
No,
because these were separate resolutions, which were one was passed by the shareholder, the other one was not passed by the shareholder.
no. So, Mr. Amit, let me put a counter question to you.
Yeah.
Say Mr. X has been appointed for a period of 5 years, which is getting expired on 30th of January 2022.
Okay.
Okay. We are not taking any action or before the completion of his term of appointment for either his reappointment or confirming that he is vacating office on that day.
Okay.
What would be position on 31st of January with respect to Mr. X? Whether he continues to be a director, whether he ceased to be a director, what is your opinion on that particular?
So my view is he will not be independent director because it is his second term is not yet appointed or confirmed by the shareholder otherwise, but he will continue to be the director on the board.
Yeah, but if we now refer to the resolution which was passed by shareholder for his appointment, they have very specifically passed a appointment for a term of period of 5 years.
As an independent director, sir. There is a
Yes.
word mentioned as an independent
Yeah.
director.
So now, just to take that particular example a little bit ahead only, when you are appointing a person as a managing director, and in case if he resigns either at the end of the tenure or if he resigns during the tenure, he would normally issue a resignation letter stating that I am resigning from the post of managing director, but I would continue to be director. So he makes his intent very clear with respect to his appointment and continuation as director simpliciter or as a non-executive director. But in case of an independent director, he is not required to give such communication at the end of the tenure. So my understanding with respect to specifically independent director is that he would be governed by the terms of appointment. And if we are proposing to appoint him as a normal director, we need to take a fresh resolution in the board or
Okay,
at the shareholders meeting.
Okay, now there is a term of say 5 years as an independent director. After 2 or 3 years, with some situation arising, as I told, his brother is appointed on the board of that company. So he ceases to be independent director, who was otherwise independent director.
Yes.
So he will also continue to cease to be a director because he ceases to be independent director because his brother is on the board. There is a relationship. So automatically he will cease also to be a director of the company. He will cease to be independent director, but he will continue as a director of the company. That's what my understanding.
So you need to specifically pass a resolution with respect to that. If you're not passing, my understanding is that he ceased to be the director as well.
I agree with Sanjay Bhai. That
A better corporate governance practice would be that.
As per a good governance practice, the members also, all stakeholders should know that he has lost his independence and whether he would like to continue as a director or not. The board has to pass a resolution that he has ceased to be an independent director. As regards the managing director, it is a different story. Say in Vodafone Idea, Mr. Himanshu Kampania was a managing director prior to amalgamation. On amalgamation, Himanshu Kampania ceased to be a managing director but continued to be on the board of the company. The situation of a managing director and an independent director, as rightly said by Sanjay Bhai, it is altogether different. So if a person has ceased to be an independent director, whether to continue, Sumit, your view is not wrong, I say, that he may continue, but a resolution is required to be passed that he has ceased to be an independent director, and so the composition of the board has to be changed in terms of your Companies Act and the LODR, so that the independent director's composition in the board remains intact. That is what I feel.
There are
instead of going by law book, we have to see the spirit also. Because at times the law doesn't say all, but the spirit says a lot about it, and we have to abide by it. Balasan, over to you.
There are two situations which is arising here. One is the person appointed as an independent director. He is person appointed as a director. He is actually an independent director right from the day one. He has been appointed for the specific term of 5 years, as per the law. Now, at the end of the specific period of the 5 years, he ceases to be a director itself, also an independent director. It is not that he ceases to be only independent director, he continued to be a director. That is not the case. Because if the 5 years term is over, so unless otherwise he is appointed for the second term, he is no longer a director in the case of the period expiring. But the other situation, when the director is appointed as an independent director for a period of 5 years, in between, he loses his independency. Then in which case, the board has to actually take a call, and the board has to categorically say, we have appointed him as an independent director during this tenure. Now he loses the independency. In view of that, he is no longer an independent director, but however, he continued to be a director, non-executive director. That resolution has to be recorded. If that is the case, he continued to be a director for the remaining term of the 5 years completion.
Just to add, when we are appointing a person as a independent director, the preamble of the board resolution goes in that manner. But in case of appointment of a managing director, you will first appoint him as a director, then put a resolution for his appointment as a managing director. So that's where the little difference would come between managing director or any executive director position and the independent director position. The appoint and in our special resolution of shareholders meeting, again, the explanatory statement also provides very clearly that the intent is to appoint him as an independent director. So if shareholders have approved his appointment as an independent director, and for any reason, if he is losing independence during the period, then his entire appointment should come to an end.
And it should go back to again to as appointment, and then again you appoint and again you take the approval.
Correct.
But if there is a separate board resolution where he is appointed as a director, then another board resolution for appointment, the same director as an independent director. And there is a separate approval in members meeting, as he was questioned. In that case, he will continue as a director. Suppose that renewal of the second term of independent director not approved, but director appointment is approved.
Yeah, I think we should make it clear in the board resolution, at least in that respect, that Mr. So-and-so would continue to be director of the company, and he's not opting, either he's not opting for the second term or the management is not opting to reappoint him for the second term.
So here your drafting skill comes, predict in advance, and like we used to say that the MD's liable will be paid in earlier days, even in the case of absence or inadequacy of profit. That was a standard term we used to write in MD. So we should now write that this director will continue as a director even though it discontinue, he ceases to be independent director, he ceases to be independent. Then if he ceases to be independent, then he ceases to be independent director, but continue as a director and take the approval of members then.
Dipti Madam, if we are putting into the resolution the intent very clearly, and if we are mentioning that in our explanatory statement as well, I would tend to change my stand in that case and would agree to this thing. But my understanding is that if we do in such a manner, rather we should opt for a fresh resolution. That would be a better practice. But if our resolution is the manner in which you have explained, he can continue to be a director.
So friends, drafting can really help you. So predict in advance. So I think best way, no, what is wrong in writing this? Like we used to write, we never predict there will be loss even
No, so Dipti, I would slightly disagree on this particular point for the reason we are taking too many of the situation in our drafting. Rather, what we can do, we can pass a simple resolution of appointment of independent director. And in case for any situation changes, we would anyway be calling for a board meeting. Convening of board meeting is not so expensive, though it is bit expensive, but is not so expensive. And in a board meeting, we can always appoint him as an additional director. And for appointment of a person as an additional director, in fact, you even don't need a board meeting. You can do through circular resolution as well.
So, okay, option is left to all participants, whatever you want. Now, next question is, first term of 5 years of independent director ended on 31st March 2021. Appointed as additional director for his second term by the board, effective 1st April 21. Got appointed as independent director at next AGM on 30th September 21. Will this be considered as appointment for 2 consecutive terms, or was it mandatory to be appointed as independent director on 1st April 2021 at a general meeting for considering his second term? Over to panel. You want me to repeat the question or it's okay?
No, I think this point has already been clarified in our earlier responses. As per my understanding, he is in a continuous appointment for the second term. There is no interruption in between.
Yeah, this has been actually stopped the earlier question actually.
Yeah.
What is non-official independent director? Mr. Amit, I'm not getting what is, even I don't know what is non-official independent. What do you mean? What is the question? Mr. Amit, can you unmute and ask, please clarify? Mr. Amit Boch? Okay, we'll take it later. Next question from Prasannaji. Nominee director, okay. Nominee, we are taking later. Nominee is not covered yet, no? No,
No,
nominee
easy
is
to
covered.
come.
We have covered, okay. Nominee directors are appointed under special statute of the FI, etc. IDBI Act, where there is a specific exemption from Companies Act 1956 earlier and now it's Companies Act 2013. To what extent they are governed by Companies Act or the articles of the company? If there is a compliance issue or a deadlock in the board, does the major provision of Companies Act 2013 become none? I don't know, none. As to if the dispute is taken to the ROC, RDMC or in court of law, including. The question is not where it's a very big thing. If it is put it, I will say that your question is whether a specific act like IDBI Act will override Companies Act. So my understanding, specific act will override when there is a conflict of provision between these two acts. That is your IDBI Act and Companies Act. Otherwise, if there is no conflict, Companies Act will prevail. Over to panel, please.
See, as far as the nominee director is concerned, it is appointed by the financial institutions who's actually lending the money to the company. Then in which case, his responsibility is only to the extent restricted to the extent of the interest, to safeguard the interest of the financial institution in terms of the repayment, in terms of the principal amount, interest amount, etc. Otherwise, as a non-executive director, he is not involved in the day-to-day affairs of the company, and he is also not involved in the decision-making processes. So he will not be actually getting either as a question puts it from the MCA, etc., and all those things. He will not be responsible for the compliances issue, etc., and other things and all on the day-to-day affairs where the executive directors will be responsible.
Dipti madam, can I just?
Yeah, please.
Yeah.
Bala sir and all the panels, everybody, a very good morning. Very nice lecture session, sir. My limited point arises from a very practical issue several years back, where a nominee director, sir, you are very right. He is the conscience keeper of the lending institute, sir. He is the eyes and ears, and his limited role is to see that the the interest of the lenders are or the lending institution is safeguarded. But what happened, sir, in this instance, without naming the entities, there was a expansion, expansion proposition of the industry. So the board was more or less aligned, to go for the expansion, but there was a stumbling block from the this nominee director. So in that issue, the question came up that whether he is only supposed to restrict himself to the lending institutions, or can he really intervene in such business decisions of the company. So in that aspect, sir, I had framed my question. It was a little longish, as Dipti madam said. So my point was whether Companies Act is totally honest in these matters, because his appointment itself, sir, the letter which came from IDBI, this institution nominee, that made a total preemption that he will not be governed by the by the Companies Act or your articles, except to the extent our right in the loan covenants. So this was the issue, sir.
Does the loan document provide for a non-affirmative vote right to the nominee director?
No, I mean, to the best of recollection, Sanjay sir, it was there were no negative covenants like that. But the appointment letter, which was conveyed by the bank nominating this gentleman, that read out all these provisions.
No, I agree with that. But from that perspective, then in case if there is no affirmative vote rights which were given either in the loan document or in it is not incorporated in our articles,
right,
then the proceedings of the board meeting should go by the vote of the majority.
Right.
Bala, I would like to make 2 points here.
Yeah.
The first point is that when a nominee director is appointed by a financial institution, the appointment is done merely by issuing a letter and receipt thereof by the company. Upon it being received, it has only to be noted by the board. They do not have to pass any resolution.
Very correct.
Though no resolution is necessary, that's why even when he's described it here, nominated by any financial in pursuance of the provisions of law, he does not require any resolution. He is just to be noted, and the directors have to be informed that so and so is a director, etc. Second point I want to make is that a very important issue is that if an investment proposal comes before the company, I'm talking about the erstwhile section 372A. I do not know what the current section is. Under that, you required unanimous approval of the board. So if at that board meeting where this nominee director is present, he says no, then does the resolution fall, or does that investment proposal fall, or his vote is not to be counted? According to me, it will fall, because he is a director, and this resolution has to be passed unanimously.
Celeste, can I just make a little distinction? What you are referring to is 372. Yes, sir, you are very right. That has to be a unanimous consent of the board, including this nominee director. But those are investments basically into shares and other areas. This was a capital investment and an expansion of a project, sir. So if I'm got it correctly, can we draw a distinction between the two, sir? The applicability of 372A and the case which I'm referring to the panel.
No, I was not referring to the point which you raised about investment in a project. I was generally referring to 372A.
Agreed, sir. Agreed. Because your point is very well taken, sir. 372A, your point, I agree with you that it should be unanimous, sir, including this nominee director.
Correct.
Yeah.
And about his appointment, that it is to be merely noted and no resolution is required. Are you in agreement with that?
Yes, sir. Only I remember, sir, that we had filed Form 32 those days, intimating ROC. Yeah.
Fine. Filing Form 32 makes him a director. Absolutely. But no resolution is required, as would be required.
Sorry, Celeste, I disagree. Filing forms doesn't make person.
Okay. Expunge that. I cancel that point. But what you're saying, you agree with me that no resolution is required, merely receipt of letter.
This is very, very critical issue. All panel member, I need your views.
Acha.
Still no. Sanjay, please, you carry forward.
No. Can you repeat, Dipti, what you are trying to say?
I think she's taking my question.
Yeah, please.
When I said that when a nominee director is appointed by a financial institution, it is done merely by way of a letter issued by the managing director or company secretary of that financial institution to this company, receipt of that letter by this company. Matter over. The only thing to be done really is to intimate the board by way of a circular, not even a circular resolution, by way of a circular, that so and so has been appointed as a director on the board by IDBI, by its letter dated so and so.
Very correct. Yeah. I would agree with Shaileshji's view. In fact, when you are appointing a person as when you are giving a right of nomination to an institution, basically that would be governed by the document which we are signing with that particular entity. And such documents are normally approved by the company, subject to authorization already given by the shareholders. So there is an indirect authorization from the shareholders also.
Very true.
So coming from that perspective, that nomination right has been indirectly given by the shareholders. In case of specific acts like IDBI Act, which is there, where this right is emanating from the particular act. So when we are signing particular documents with that particular entity, we are accepting the application of that act as well. So in all these cases, appointment would be effective from date of nomination or nomination letter issued by the such institution. filing of form
Has nothing to do.
is a procedural
Yes, yes.
aspect which company
Absolutely.
need to comply with.
No. Dipti was absolutely right in that.
Yeah,
No question.
but what I would like
But
to
I would
add,
just make one small
Shailesh
correction.
bhai,
It is
sorry to interrupt you. Why that is more important? Your view is there, but why is more important for the participants to know that since we are adopting in the board of directors the sanction letter, which may have a clause for nomination of the directors, so at that time the board resolution itself is passed that
Very correct.
IDBI has a power to nominate, whether they appoint Sanjay, whether they appoint Shailesh. It is a different thing. But the directors in the board meeting have approved and taken note of that sanction letter. They have given the approval. So all the terms whatsoever has been the consequent actions, no resolution, further resolution would be required. A noting would be required mentioning that whether Shailesh Bhai is appointed or Sanjay Bhai is appointment. That's it, and a form required because that is a requirement. If that is not filed, the MCA may not show the correct data of the directors on the board of the company. So, but the logic is that all that conditions, as Sanjay Bhai has said in the general meeting, they have adopted a resolution for getting a loan, for mortgaging and creating charges on the assets of the company. And in the board meeting, they have approved the sanction letter, and hence no further action would be required from the board.
May I speak here?
Yeah.
Hi, Ashwini.
Yeah, so
Yes.
hi, hello, sir.
Hi.
So in one of the government companies that we are auditing, they usually only place the letter. They do not even mention the name of the director who has been nominated. They just say that by the circular, we are noting the circular. I think Shailesh sir may be remembering this. So we have done audit for one government company wherein they just note the circular by which a director has been appointed. There is no resolution, nothing. And then we file a form.
This company of yours is in a class by itself. So less said about it, the better.
So
No, but then this is what happens because they do not have. They say that we do not discuss this. There is no resolution to be passed, so we'll just note it.
But Ashwini, the
Note
board
the
of directors must know who is their new colleague. Who is their new colleague? They must know that, no?
So basically, if you are dealing with government companies, each government company is having a different set of rules and policies for themselves, and they go by that policies only. So I had chance of be on board of the two government companies, and they have taken in this aspect is that they would not discuss the appointment, but they will pass a formal resolution. And the resolution wording is basically going in this manner that resolved that the circular, the nomination letter received from ABC Limited appointing Mr. XYZ as the nominee of the company and nominee on their behalf. B&D is hereby taken on record and necessary resolution, necessary form be filed with the Registrar of Companies.
This is fine. It should be done. So that everybody knows.
Yeah, Mr. Snell, I'll give you the opportunity.
The PTC India, Sanjay Bhai, PTC India Financial Services also incidentally happens to be a so-called government company promoted by Power Finance Corporation, which in turn is promoted by Government of India, and they have their own issues. So better not to talk about any companies as such.
They write actually their own code of companies act.
Yeah, they have their own corporate governance code. They are governed by
wanted to speak. Mr. Snehal, you can unmute and speak, please.
Hi, this is Miss Nehal actually.
Oh, sorry.
No, it is just one doubt with regard to nominee director. For example, if a board resolution has been passed for a letter has been received by the institution and board resolution was passed to appoint as a nominee director, then can the directors, if a director gives the resignation, can the company accept that resignation or it would need the withdrawal letter from the nominating authority?
Withdrawal letter would be required.
I disagree. No withdrawal letter. It is an independent choice. If he might have left the job or has been sacked out of the government, and if he tenders his resignation or he is moving to government or he is into the loggerhead with government, there are chances, it is a human behavior, that a person is at a loggerheads with government of India, and if he tenders the resignation, once a tender, see the appointment, here you have to differentiate two things. One is the nomination by government. The second thing is the individuality of the person who is appointed as a director. It is not IDBI which is appointed. It is Bala who is appointed by IDBI. Now, if the Bala does not want to assume that responsibility, you have to accept that resignations. Otherwise, Mr. Bala will file DIR 11 and get rid of the company, saying that goodbye Tata. So you have to accept.
There are two issues are coming out here. One is the resignation of a director. Resignation of a director is a choice of the individual. The individual says that I am actually resigning. That can be accepted. But the thing is, when it comes to the charges, suppose the charges are there and other things and all those things, by the time, suppose even if the repayment of the loan is done, okay, even then the nominee director can resign. But the thing is, for the satisfaction of the charges, you need a letter from the financial institution. By virtue of his resignation and the payment is made, you cannot file the satisfaction of the charges. But here the individual choice, he can resign and it is accepted. But the only thing is they need to nominate somebody else.
Right.
Yes,
So,
yes, I agree.
I have 1 minute.
Only thing what we really need to do in this case is, as Bala sir has rightly said, it is an individual choice for resignation, and company will have to take that on record. But when company takes such resignation on record, company should also write back to the nominating company that so and so person nominated by you has withdrawn his nomination, has tendered resignation, and accordingly that the nomination is vacant now.
Correct.
And then it would be a choice of the institution to nominate somebody else.
Yeah.
I'll put that way, Mike, that when that person was appointed, whether his consent was taken or he was appointed because of his position. He was not appointed, he was representing IDBI. So it is IDBI who appointed. Who has authority to appoint? IDBI. And that's why you are not even passed the resolution. That individual was not having say. It is in between. So my view differ. It is IDBI who has right to remove that person or change the person.
No, removal is
different.
Removal is something different.
Remove in the, I say change.
We are talking a resignation.
Resign.
1 minute. I am coming to that. That position. Let's take that position of nominee director. Is created because of your sanction letter. Its appointment and change in that position, individual occupying that position will be controlled by that IDBI. Now, in that scenario, when a person is appointed, I'll put that way, it is the internal administration of IDBI and rules and regulation. Who will be appointed, how he will be removed, how he will be changed and all that. Now, suppose this person has resigned. Honestly speaking, we cannot work out ourselves. We have to intimate IDBI, boss, your person nominated has resigned. Now you change another person, then they have to say, okay, we are appointing, let them decide. Now, whether it is effective, and we have to say that whether we take this as a vacancy of position or we have to take it, you are appointing or the person continue. And let them handle and tell it. According to me, that is the see, because suppose their terms says that they cannot resign, and we ourselves decide that no, we can resign, and we are filing the form. So we have to take a clarification from the respective organization. That is my view. I'll leave it to Frank.
Dipti madam, can I supplement on what you said exactly?
Yeah, one by Mr. Prasanjit, you, then Mr. Dilip, and then all this.
Thank you, madam. I will just close this here. Thank you for all your consideration. Yeah, I just align to what you're saying, because the case study which I raised to the panel, you're very right, madam. The appointment, the nomination letter which comes from the institution is very specific. It says that unless the nomination is withdrawn by us, that is the financial institution, he will continue to be here, and any changes, etc., will be done at our apex level. This is exactly what you mentioned. So I align with your view that the board suo motu cannot take this resignation, although it's an individual choice, but this individual is under the administration and control of the institution. So he has not come as a individual and a free director in that sense. So that is one point, madam. And the last point for the panel and you is that in this connection, the institutions also provide an observer who, when the main nominee director is not present, he is in the board. So his role, in my understanding, is just a passive role, as I've seen him in certain board meetings where he attends. So he cannot have any say in the decision of the board. He can only go and report back to the original director and the institution what has transpired, or if there are any differences, it has to come from the original nominee director. Am I correct in assessing this?
Yeah, now his question specific that if the letter says that this director or his appointment or his contribution or rights, duties, responsibilities, powers is not governed by the Companies Act and article, but governed by IDBI Act only. In that scenario, what his question is that way, what will prevail? IDBI Act, Companies Act, and article. Panel?
When there is a resignation, it is the individual concerned. I do not want to continue as a director here, irrespective of whether I've been appointed as an ordinary additional director or whether somebody else has appointed me. I do not want to continue. If I do not want to continue, nobody can force me to continue as a director. IDBI can sack me, whatever they want to do, but they cannot force me to continue as a director. It is incumbent upon the company to, at post haste, immediately intimate to IDBI that so and so thing has happened. His resignation letter has been received, noted by the board, and he no longer is a director on the board. You are required to take necessary action, whatever you deem fit in this direction.
Shailesh bhai, I 100% in agreement with you, because I am not in today's situation. I am talking about some 30 years back. In fact, 1994, I think, if I'm not mistaken, 94 or 95, the company where I was working, we have taken the loan from the IDBI. That time they actually nominated director. He is a well-known director. I don't want to take the name. He was a very good person. He was working with us. He was actually nominee director. But some or other, he had some family problem, etc. and all this. He was discussing with us. One day he told that I don't want to take the responsibility of continuing a director, etc. I would like to submit my resignation. I'm informing to my organization also, but I'm not resigning from the IDBI. That is what he said. In the next board meeting, when he came, he submitted the resignation. In the board meeting, we accepted the resignation, we recorded the resignation, and we took out the certified copy of the board resolution along with a copy of the resignation letter. We have sent it to the IDBI. Your gentleman who has been nominated, he has submitted resignation. Here is the copy of the resignation letter. Here is the board which is for the resolution accepting his resignation. You may decide to replace your nominee. That is what we have done in reality as way back as 1994.
So there is a different view prevailing. Dipti, I will add one aspect, further aspect to this. There is a loan which is being considered by IDBI, or some investment which is being considered by this company, which this director personally feels is not all right, but this company plays with IDBI, uses various methods to get IDBI's okay, but it's a patently bad investment. If this is then approved and it then falls bad, this man will be held responsible. How did you do it? He may want to leave the company. He may want to cease to represent IDBI's interests because he knows that there is some hanky-panky going on here. He cannot be forced to continue. That these situations can also arise.
I also agree with Shailesh by whatsoever he is saying. Say it is an individual's choice. Yes. IDBI, a person can nominate, but yes, he cannot be forced to continue because it is the individual responsibility. Maybe if he is all exempted from all the responsibility, it is a mental stress. and as an individual, he cannot be compelled to continue as a director. If he is resigning, it is up to the baby of IDBI to appoint an alternate to that particular gentleman who is feeling uncomfortable. So simply that it has to be backed by IDBI. If it is a reverse situation, IDBI wants to say, take the nomination back, or IDBI wants to appoint Mr. Y in place of X who was nominated, and if X doesn't resign from the board, whether you would not file resignation? Yes, because you will file his resignation saying that his term is terminated by IDBI. Who was nominated, they have withdrawn appointment. That is a different thing. But individual cannot be, he can be nominated but cannot be compelled to continue to be on the board of the company and dragged into all controversies.
Yes, correct.
Okay. Sanjay bhai, your view. So all three panel are in the favor that he will resign. Sanjay bhai, your view?
But if
So,
woman director is against us, we have to fall in line.
Sanjay bhai, your
So
view?
I would also agree with the individual choice of a person. So if a director is resigning, as far as the company is concerned, company is required to take that on note, and whatever other action company has to take that with the nominating institution, that's a different thing. But a person cannot be forced against his own personal wish to continue as a director. If he has
we cannot tell
some
the
Okay,
reason.
can we take it a view that way that it should be allowed individual resignation is resignation?
Yeah, we
Yeah.
cannot say that unless IDBI says
Okay,
resign, I cannot take a
majority
resignation.
win. Okay, on the same topic, Mr. I think Mr. Dilip, Mr. Avdesh or Mr. Dalip, anyone on the similar topic want to comment or otherwise?
Dipti
Dipti,
madam.
I have a suggestion. It is 12:30 p.m. Say a single topic to be dragged too much. I think the residual portion of the presentation also would be left out because our timings are from 11 to 1. So let us move ahead with cut, and I think you can moderate and some of the things, and let us move ahead.
Yeah, so in that case, this case, as we agree that individual can resign and you have to intimate the financial institution to take the call and replace the person. Now, only one question, and Umesh bhai, we will close at maximum by 1:15, 1:20 only. We'll continue the same topic next Saturday. And I will request you all to both the panelists to again spend time.
No, we are here till 1:15, 1:32. We don't have issues. The participants may have their own time frames. That is the issue.
No, we generally take a discipline that we
We generally close the time. Maybe the overrun is only some.
because it will not over in 15-20 minutes extension. So we
Yeah. Please, go ahead.
But you both has to be there next Saturday also. I'm taking permission now only. Okay. Now another question which I think Umesh bhai better we discuss because it's very interesting topic rather than living and rushing. We will take it. That very interesting question which he asked there. In case of there is a provision that in your sanction letter it is written that only the provisions of IDBI Act is applicable as regards powers, duties, responsibility and all that, and participation, decision making and all that. Whether Companies Act and articles will prevail or IDBI Act, what is your view? Each panelist one by one, please.
Companies Act shall prevail. Nobody is having an immunity from Companies Act. You cannot say that Companies Act, whatsoever is written, you may give a loan or you may take 60% more than above. The Companies Act shall prevail. That is the mother act. While we were studying, it was taught that memorandum shall prevail over articles and Companies Act shall prevail over memorandum. That is what we were taught way back in 85, 86. So what we do is that the Companies Act shall prevail so far as it is not in contrast with the provisions of the any IDBI Act. And by and large, what my experience of 3 decades says is that the company, all the provisions in the law except this LODR, which is having an overriding effect for listed companies under the Companies Act. Otherwise, all are in sync with each other. and the onerous. See, as a corporate, as a professional, our duty shall lie that the most onerous, whatsoever all the acts, they have to prevail, they have to be complied with. It is the law of the land. Now today, SEBI even say, I'm diverting little bit, even the SEBI Act was not having any sort of a limitation act. And they were passing on the things and the orders of inspection and investigation 12 years, 15 years, 20 years back. Now even the parliament is thinking to curb and bring the limitation act as to what they have brought under the Income Tax Act. So by and large, all laws are in sync with each other, but as regards we the professionals are concerned, we should be governed by Companies Act and it should prevail over all other acts.
Okay. Mr. Sanjay?
So there are two parts. My understanding, I agree with Umesh Bhai on that particular part. As far as the company is concerned, as far as the company is concerned, Companies Act would prevail. With respect to the nominee director, he may have some immunities available because of the provisions in the IDBI Act. But as far as company is concerned, it would be the Companies Act which should prevail.
Sometimes the lending institution requires that the resolution which is noted by the company has an additional clause which says that this person is being appointed by virtue of the loan extended by so and so, and that he shall not be liable for the acts of the company, etc., etc. Something like that is very often added.
Shailesh, I have mentioned that part only, that because of the act, he may have some immunities available to a person who has been appointed as nominee. But when it comes to the company, if I have to do certain compliances,
yes, I agree.
I have to follow the all thing which is mentioned in the company.
Yes.
Absolutely, I agree with both of you, because the companies are registered and incorporated under the very same act of the Companies Act. The company is to require to comply with the various provisions of the Companies Act as per the company is actually concerned. That is number one. So Company Acts always prevail from the company's point of view. But as Mr. Sanjay Rathi has put this very clearly, if the person by virtue of his appointment enjoys certain immunities, the recognition to that effect has to be recorded by the company, so that to that extent he is not governed. That's all.
Correct.
Otherwise, the Company Act prevails.
But can he participate in discussions or not?
Surely, sir, he can participate in all the discussions.
Why not? He can. He is a director. Nominee is a added qualification. What is
having? Yeah. Sorry, Umesh Bhai. Please continue.
No. Nominee is an additional qualification. What he is having, he is the part of the board, and he can very well participate into all the discussions. And what my experience says that for all practical purposes, the views of a nominee director are well considered by the board also, and the board look forward to them for their inputs.
Only thing is, poor chap does not get sitting fees. They go to the lending institution and not to me.
and get him changed, sir. That is the easiest thing to do.
So the conclusion is that yes, it is Companies Act, it will prevail so far possible.
And one company gave ESOP shares to him, and there was a huge thing that happened.
Yeah, I think Mr. Dilip, if you are want to talk. Mr. Dilip, you have raised the hand and
I can see the 3 hand raised actually.
Okay, Mr.
Dilip,
Jagdish Bhai, Mr. Dilip is not there, you can say, please.
Sir, Section 6 of the Companies Act specifically overrides all the provisions of resolution, agreement, etc. So there is no need of any deliberation. Companies Act will prevail all over the agreements.
Okay, thank you. Okay, now let's another chat question we have to take. It was nominee director are appointed. Okay. in respect of independent director, they are guided by the provisions of Companies Act rules schedule. Usually it's found in practical experience, the independent director generally distance themselves from the core business affairs of the company, which they are expected to know and contribute with their professional experience. Except the day-to-day affairs in the company in cases if investigation or any mismanagement issue. They generally try to seek immunity. What is the view of MCA and the courts with a few landmark judgments? Please, at least, second question, at least one meeting of, अच्छा ये एक ही question रहता है. First, that he tried to keep and take immunity. What is the view? I think otherwise also it's a view of MCA and all that. They are not expected to involved in day-to-day affairs. Other non-executive director also, they take reports, certification, MIS from the management and the other executive director, and rightly they can rely on that. And if they found something improper, if they raise their concern, and many times I think they have right of immunity, and all the ministry and judiciary take the same view. I think over to panel if any other view.
So I would agree with Dipti on this. Basically, it's the independent director by nature would be a non-executive director. So number one, he is not into day-to-day operations. Secondly, as an independent director, he would have access to all the compliance certificates which has been issued by various executives of the company and submitted to the board for regular compliances of the company. So taking that particular view, an independent director can, as well as an non-executive director, can always claim immunity from and distance himself from any irregularity which is there. However, we have seen certain circumstances when I won't be able to cite exact case law or other thing, but we have seen certain circumstances where notices have been issued to all the directors, including independent directors, with respect to certain non-compliances. It's only after they submit their immunity and they give their justification why they should not be penalized for the non-compliance part, the regulators take a view that they should be absolved.
Absolutely, your view is right, Mr. Sanjay. Because I have actually seen what the MCA does is MCA actually goes by the number of directors who are actually present. The notices issued, all the directors, even the company secretary.
Sir, I'm not saying only from the MCA perspective. We have seen these notices coming from Weights and Measurement Act and Fire Department and Factories Act everywhere.
Okay. So normally it happens because they pick up the database and who are the director, all the director by rule they send it. Right. It is only after notice is received, you have to explain to them what is your position, how you are not involved, etc. Then they take a call, they drop you. That is there.
Okay. Now the
Sir, in the recent adjudication order passed by ROC Gujarat, we can see that it has been issued to all KMP. The order has been issued to KMP, whether he was there or not. The current AMP and the current directors are charged for the violation which has occurred in 2015. So it is altogether a different thing, that it is upon the individual, the corporates to fight out the notices what has been received, because there they don't the regulators do not differentiate the nominee or independent director or the promoter directors, and they thread and bed across the board. They issue the notices. It is up to the company and the individuals to fight it out whether they were responsible or not responsible.
Yeah, once you become a director of a company, you inherit everything from the company. Ultimately, you have to justify.
Okay.
It is an onerous responsibility, sir. Prior to 2013 Act, I recollect, it was a prestige and an ego issue to become a director of the company. Today, to become a director of the company has become very, very onerous, and the people are afraid to become a director because at times what I have seen is in one of the recent cases, I won't name, a director was appointed only for a period of 3 months, and that something was committed during that particular 3 months. There was a CBI raid into all the directors, the then directors and the current directors before a couple of days back. Nothing could be found out from that gentleman. The only thing was that certain liquor bottles were found. He was having the permit from the government of Gujarat to hold the liquor. Now, nothing was found out by CBI, but because of the ego and the clashes what he had with the CBI officials raiding his house, CBI filed a case for illegally holding more bottles, because while giving the permit, it is being specified that you have to consume that liquor within that month. Now he didn't consume, and he had some more stock into it. He was charged by CBI for holding illegal stock of liquor, and he was behind the bars for 4 days. So you never know as to becoming a director may put you where. So it is always better to be on the right side of the law, and whether to comply it into the law and spirit. Don't go by only words, but what is the spirit has to be complied. And that we as a torchbearer of the profession have to canvass it, that though it may be onerous, though it may be expensive, you have to do it, or else close down the company and open a proprietorship firm. That's it. Simple as that.
Okay, I think Mr. Anshul on the same topic. Welcome, Anshul.
Yes, thank you, madam. On the same topic, I wanted to say this. Even the section 149 very specifically mentioned in subsection 12, I think, notwithstanding anything contained in this act, an independent director shall be held liable only in respect of such acts and omission or commission by a company which had occurred with his knowledge attributable through board processes and with his consent and connivance, or where he had not acted diligently. Apart, if rightly pointed out that the notices are sent to all the directors, and but by the at the time of replying of those notices, if this particular aspect can be proved by those directors, then I think registrar or any other authority cannot charge him for the wrongdoing of the companies.
Okay, thank you.
But Anshul, if there is a nominee director who is aware due to board process, etc., about something which is subsequently held to be illegal and prosecutions are launched, if the person is a nominee director and not an independent director, a nominee director, would he be liable or would he not be liable?
So same provision is also applicable for the non-executive directors. If he is a nominee.
I'm talking about nominee.
So nominee director can be the non-executive only. I don't think he is holding an executive position. So similar provision which I have referred, it is applicable actually for independent director as well as non-executive director both. Since this question was related to IDs, so I have not used the word non-executive in my statement.
No, I would just distinguish here a little bit between non-executive director and nominee director. A non-executive director is an ordinary director, but a nominee director is there only because of the loan given by the financial institution. And his job is not to contribute anything to the company, but merely be a watchman to see that that loan is being repaid properly, etc.
Not only this, sir, but if suppose something is you're rightly saying that his primary job is to be a watchman for the loan granted by the financial institution, but it does not mean that he will simply ignore all other aspects of the company. If company is doing something weirdly wrong, he has to open up and say the if he is receiving some kind of board agendas which is actually talking something which is not in the interest of the company and all those kind of things, and he is simply saying, I am a watchman for my loan, I don't worry about what company it does. I think this is not a correct position on the nominee director also, on the part of nominee director also.
I would like views of Bala on this. Would the nominee director be liable? He keeps quiet. He is like a fly on the wall. He is attending board meetings, does not normally participate in it. Yeah, and there is some fraud happening. Through board process, etc., you can say that he was aware.
No, so long as he is not the party to it, he is not, participation, he has not consented anything, etc., he will get exempted actually. He will not.
But he's aware. But he's aware.
Bala sir,
Yeah.
non-active participation is there. I mean, in fact, he has not raised objection on that fraud which is happening. If he is aware of that fraud and he is not objecting to it, in a way, indirectly, he's conniving to that particular position. And then that particular section, what Anshul was referring, 149.12, would also not come to his help.
Yeah, that will
Yes,
not come.
exactly,
That is right.
exactly.
Yeah, that will not come.
And
That will not
that
come.
is why my view is that nominee director, you are telling that it is just his duty, his interest or duty is to receive payment and all that repayment interest. Then you don't create. One thing we have to keep in mind is a director.
He's a director.
Nominee, but director.
Director, yes, correct.
He is not just a dumb person that just interest liya. According to me, he is a director. We are giving membership of the board prime importance. That's why you can't say that way. And I think Mr. Jagdish, but Jagdish bhai, you want to say something? Hello, Mr. Jagdish Patel? No, I not there. Okay, there is another question that at least one meeting of independent directors in a financial year is necessary to be held and reported in the director's report. Since this meeting is generally confidential and the independent directors are reluctant to share the details and not keeping minutes of such meeting, what is the responsibility of the CS to ensure that all governance requirements are complied with? Over to panel.
So repeat the question. What's the question?
Yeah, please. Sorry. At least one meeting of independent directors. The question is, I'll narrate. We should have one meeting in a year of independent directors. Now, that meeting is generally confidential. This director do not keep minutes of they don't give details. The independent director, Mr. Sanjay, the question is, once in a year we have to have a meeting of independent director. It is confidential. The directors are not sharing the details. They are not allowing. They have written it is that and not keeping minutes of such meeting. What is the responsibility of CS to ensure that all governance requirements are complied with? Please, your views, Mr. Sanjay and Mr. Umesh.
According to my view, if no records is provided to the company secretary, there has to be, I always tell Dipti, since inception, when I go through take lectures in MSOP, there has to be back diary papers or your working papers. You should send a mail. It should be there on record that you had inquired for it and you were not provided the information. If you are not provided the information and if you can sufficiently prove that you had attempted all the diligence whatsoever was possible for finding out the details and information to take the same on record, probably there would be no responsibility on the company secretary for non-compliance, if at all, done by the independent directors. But if it is not proved beyond the doubts and the directors turn their back saying that we were never inquired about the same and we have all these things, then the company secretary may be in a soup as such.
Okay, Sanjay, Mr. Sanjay.
Okay. As per my understanding, we need to keep minutes of the even ID meeting as well. Only, and for that purpose, the company secretary is required to approach lead independent director and seek his note on the independent directors meeting if he is not part of that particular meeting. Normally, the independent director may choose to remove certain sensitive information which they want to keep between the independent directors only, but they would give certain feeders to the company secretary for creation of the minute and creation of record. I think that's the approach we should take for compliance part.
I also agree because there is no exception that you are not required to keep minutes and all that, and no record should be maintained. There is no exception. So one has to educate it and communicate that you are responsible, and if this is not done, of course, CS will have to say that I have to note it and create a record that you are not giving, so I have not prepared minutes. So then in that case, you are responsible. You are right.
And
Mr.
as if Dipti is my practicing company secretary, she would surely qualify that the ID minutes are not available.
Yeah, there is no exception or that we provided any exemption. Yeah, Mr. Prasannajit, Mr. Avdesh, if you are on the same topic, you can.
Yeah. No, madam, this was my second question, which you just.
I will wait. Then there is I will cover chat and then I'll give you.
No, I'm saying this is on the same question.
Okay, sorry. Okay.
This was my question on the minutes. So to the panel, both Umesh bhai, Mr. Rathi, Shailesh bhai, and Mr. Bala, that sir, the point is, of course, the Companies Act, the secretarial standards gives a mandate to the company secretary, but there are in certain issues, this meeting, as you would all agree, the scope and jurisdiction of meeting is where the independent directors do an assessment of the other members of the board, including the chairman. That is precisely the scope of this meeting. So number one, the company secretary cannot never be a privy to such a meeting. Number two, there are, in a practical world, there are jurisdictional issues, like to the principal ID, independent director, one may approach, etc. But sometimes it becomes a little sensitive and tricky line. So in that aspect, I was saying that if I get a communication that this meeting has been conducted, so do I need to go beyond that, as Mr. Sanjay said, that once you have a positive or affirmative confirmation, that is sufficient to discharge your role as a professional. So can I live with that and stop at that, sir? Because stretching it too much could be also a little sensitive in the practical and the corporate world, I'm saying, sir.
I'm in agreement with what Prasanjit says. I think the role of a company secretary, as far as this independent directors meeting is concerned, is limited to his convening the meeting, ensuring that the meeting is held, and checking with the lead independent director as to whether he would like, if the lead independent director would like him to be present at the meeting and to take minutes thereof. He is to then be guided by what the lead independent director says. According to me, there is no compulsion of minutes also here.
In one of the Vodafone Group company where I was working, there was an unlisted public company which is actually governed with the provision of the independent directors. And they used to have the independent directors meeting. In fact, they used to ask me to organize for a meeting room, etc., and other things, and all these things, provide the thing which I used to do. And ultimately, when the meeting is over, they used to give me a feedback saying that we conducted the meeting, all the records are actually maintained by us. That is what they used to have. I used to take it with me. I used to close the chapter. I never asked for what is the minutes, what you have discussed, give me the copy, I want to keep it with me. I never asked that. But the only thing I have to say is independent directors have commenced the meeting and they conducted the meeting for the compliance purposes. That is what I used to get it done.
Mr. Avdesh, you want to on the same topic or?
Ma'am, I wanted to ask pertains to appointment of nominee director only. Actually, minutes back I had raised hand, but that time,
Okay. Sorry, so many people. So please.
So may I ask or
Yeah.
Please ask.
So, sir, as panel pointed out that there's sort of consent is required sometimes, indirect consents also from members in order to appoint nominee director. But sir, 161(3) powers to appoint nominee director is vested with the board itself, and if loan is within the purview of section 181C, then at that condition even the shareholders approval shall not be required. So I just wanted to ask that, can you please throw some light on the situations under which members consent is required to be obtained pertaining to appointment of nominee directors?
Maybe if he's the nominee of shareholders, a joint venture partner and all that stuff, that nominee director, not a nominee director of a financial institution for a loan. Maybe, maybe just some light on this. Because a nominee director can be a nominee director of a 10% shareholder. who may have some right to appoint a director. There maybe you might require, because there is no IDBI Act or the LIC Act to protect you or to guide you, there you may require to take approval of the shareholders.
Umesh bhai, Sanjay bhai.
So we have come across such a situation where by virtue of a shareholders agreement, both the parties had right to appoint nominee directors, both the shareholders. None of these parties are part of any statutory organization. These are all private corporate bodies.
Private parties.
What we have done in that case is we have done two things. One, we have incorporated that particular provision in the articles of association of the company.
Correct.
And then the right available is exercised by both corporate bodies by sending the nomination letter. So effectively, that's the way we have dealt with that particular thing.
I see. So no voting, etc. Huh? In that case.
Voting.
No voting.
No voting.
Okay. Then here another question: if in a private limited company, or can we take a chat box? Now I will ask the panel since it's 1 o'clock. There are still 38 new messages in the chat box, and we are not completed half the presentation. You are at a task, so I want to ask you. Even the presentation will not complete fully in half an hour. We'll close at 1:30. So what we should do? We should move to presentation or take a chat box question.
I think we can take.
Diptiban, let the chatbot question be taken as a separate topic and let the presentation be get over. So I think chat box we can have us altogether a different mind frame without going into the presentations. We can discuss one by one issues and get back. It would be something like a study circle meeting if we go by chat box. And let this be a lecture meeting.
In
My
that
view,
case,
Balasan and Sanjay bhai and
ઉમેશ ભાઈ પછી CPA hours આપવા પડશે તમને.
the chat box, we are not taking any topic which is not there, we have taken. So actually chat box is covering only on the independent and nominee only and the director and appointment. That only is going on.
That is the reason I was suggesting that we should move ahead with the presentation. Let the team from Meta and Meta scrutinize the chat box. Common queries can be posted out. And then say we may circulate these queries to all the participants. They are ready. And we can have a panel discussion for question to question, one by one.
In that case, you are telling let's finish the presentation.
Exactly.
All the question in chat box will take in the next session as a only critical issue.
So that at least the duplication also would be avoided, no Pritiben, because there might be, there must be some duplication also.
Honestly, very frankly, everything is a different question if I'm scrolling on. So, Mr. Bala, what we suggest is
it is up to you. It is up to you.
You are the moderator. You have to take a call.
In fact, it is better that we deal with the questions because we have decided to continue the session the next week also. I think it is better.
We go by what Bala sir says.
Because it is better to answer the question then and there so that, at least we don't have to again do the job of scrutinizing the chat box and doing the job and again getting consolidated, analyzing it, that we need not. And we can continue the further presentation the next week. That is my view.
Okay, fine. So we have no issue if you have to do extra work, but okay, my concern was, Umesh bhai, in half an hour, I doubt the presentation will over. It will be like, reading out.
Yeah, it will not get over. Definitely it will not get over because
it has many topics also.
Such an interesting subject.
We want to scroll you. So we will do this now, question answer only. Now, next question is, if in private limited company, there are only 2 directors with only, there is one more question. That if in a private limited company, there are only 2 directors with only their shareholding, and if both are sent to jail, then how to appoint new director?
Both are sent to jail.
All the general meeting have their proxies being signed, because once a week the meeting is allowed. I had happened to visit the promoter, and once a week the advocates or consultants are allowed to meet him, get the proxy and get the new directors appointed into their place.
Okay. Okay, next question. Section 152, subsection 5 states that a person appointed as a director shall not act as a director unless he give consent to hold the office as director, and such consent has been filed with ROC within 30 days of appointment. Does this mean that till the time DIR 2 informed DIR 12 is not filed, the person cannot act as a director? Shall I repeat the
No, but what I feel is that Dipti Ben has a usual practice, unless and until the director gives his consent, we as a normal practice into our firm don't pass a resolution appointing any director. We make it a prerequisite that he has to give the consent, and based on that consent, that his consent is received, and then only we appoint. So the question of not acting does not arise at all.
And secondly, when we are passing a resolution, normally the resolution is worded in this manner that Mr. and so, after obtaining his consent, be and is hereby appointed.
Yeah, who has consented to be designated.
Who has consented to be appointed.
Yeah, exactly.
Correct.
So this question does not arise.
So the prior consent is necessary, and his appointment consequent to that is also necessary. Both is there, then no one can stop him to act as a director.
As a director,
He is the director from the day he is
Filing
appointed.
form is a different thing. It's a compliance. If the
That is a procedural.
Yeah, because that is a procedural issue. The right
if
from
the
the day.
company do not comply, that does not stop a director to act as a director.
Correct. The day
His
he is appointed, he is a director, he can exercise all his powers.
Is consent to be given even by a nominee director?
Shailesh Bhai is, I think, amazed with the nominee director.
Shailesh bhai, તમે યાર Googly નાખીને confuse કરી નાખો.
No, it's required. According
Yeah,
to me,
it is required. It is required.
It is required, sir.
It is required.
अरे वो क्वेश्चन आ गया, मैंने पूछा था कि when he appointed, no one take consent, तो आ गया.
Nominee director has to give DAR 8, he has to give MVP 1, he has to give his content, everything he has to give.
Yeah, there is another question from Mr. Prasannajit. Mr. Prasannajit, I think you are the most active and maximum participant. On subject of board diversity and role of women directors, it seems in Indian context that the companies usually meet the minimum threshold number of women directors and not broad base the board with representative of women director. What is the vision and mission statement of MC? See, I will just do because of paucity of time, I'll say what is the view of vision statement of MC on this aspect. I made it clear that I'll put it that way, that even though a housewife of a promoter director is added, please note that she attend the meeting. I have experience after 5 years she is taking part in the operation. Not only that, many times housewife turns into the very enthusiastic leader for a CSR activity of the company. So I think it is taking shape. Rather than, it will take a time, with the pace of time it will improve, right? Panel, your view?
At least in one of our company, there are out of 7, there are 3 women directors. So we have a real good presence of women director, and all of them are participating women directors. They really participate, and their opinions are carrying good weightage, and they are heard properly, and the board is acting on their advice and their suggestions in the board meeting.
Great.
So if you have a good participation, and if there is a good input coming from a director, irrespective of the gender, that would be taken on record. That's what is my perception out of all my experience of so many years.
Great. Next question by Mr. Shailesh Daga. If an additional director appointment is regularized by postal ballot, Does it still require regularization at ensuing AGM? This with respect to new regulation of LODR. Over to panel.
I didn't get LODR, how far it is related to getting the postal ballot appointment has to be confirmed within period of 3 months. Now, if that additional director is confirmed in the general meeting or by a postal ballot, I think it suffices. How far it is, what is the exact query he has and what compliance to be done for LODR, I fail to understand.
Just to add to what Umesh Bhai has said, the moment his appointment has been regularized in the postal ballot, he ceased to be an additional director. He is a normal director.
He is a director. That's
so there is no question of once again taking regularization in the AGM.
Thank you. While appointment of an individual as MD, it is mandatory that he has to be resident. Later on, if he becomes non-resident, can he continue as MD? Over to panel.
there was a director, I won't name the company, we all are aware, Sanjay Bhai, Bala sir, Shailesh Bhai, you are also aware that there was a director who used to run the big conglomerate sitting in US or UK, and he was asked to visit India, ke bhai India ke company chalao. I don't think that that is a question of him continuing as a managing director. Maybe he might be coming for a day or two, putting his attendance over here, and then move back to US or UK. But yes, 180 days and now that too has been exempted. I don't know. I have to see the circular whether into these COVID times, whether there was any exemption given. I have to check up. I am not aware. Sanjay Bhai may be aware about it.
It was mentioned no, in the starting in the presentation. There is a circular and that for resident director, it was mentioned. But what they are telling that if it is mandatory, and if he becomes non-resident, can he continue as MD? He was resident. For MD, residency is compulsory. He was resident, but later on he become non-resident. Can he continue as MD?
That way we have to see Schedule 4 whether he becomes disqualified. Whether we have to check up the schedules, whether the disqualification to become a managing director, Schedule 5 or okay.
Because this question comes that this
basically all these terms are applicable at the time of appointment. So if after appointment he has become a non-resident director, non-resident, we need to just check whether he can continue.
See, Sanjay Bhai, I am reading Schedule 5 for the first time into the presentation. Into this program, I am referring the act. It says that Schedule 5, no person shall be eligible for appointment as a managing or whole-time director or manager of a company unless it satisfies the following conditions, namely, now subpart E says that he is resident of India, but that speaks at the time of his appointment, as rightly pointed out by you. For the purpose of this scheduled resident in India includes a person who has been staying in India for a continuous period of not less than 12 months immediately preceding the date of his appointment as a managerial personnel, and who has come to stay in India for taking up employment in India or for carrying on a business or vacation in India.
Yeah, exactly. That's why this questioner has asked.
No, but that is for appointment only, as rightly pointed out.
Exactly. So see, that is the question. That this is the requirement of at the time of appointment. So
appointment only. He may
so
continue.
I will say that the answer is yes, he continue as MD even though he become non-resident, because this requirement is only to be fulfilled at the time of appointment of individual as managing director. Is it
he continues for the present term. At his next term again that would be tested.
That time, because it again it's a point. Next question: in private limited company, there is one director who was appointed as an independent director with effect from 1st April 2009. It is required to register his name in independent directors database portal and has to comply with the provisions of section 149 of Companies Act 2013. As appointment of independent director is not applicable to private limited company as per the company. Okay, so it's that question is that company is not statutorily required to appoint independent director. However, they have appointed, whether they have to ensure that his name is in database portal and section 149 is complied. According to me, no, it is not required.
No.
Okay. Next question. Yeah, please.
I have a little different view. If
Achha.
you want to comply with particular section, even if it is not applicable, you cannot choose to be complying with that in a partial manner. In case if you want to designate that person as an independent director, you need to ensure that he is updated on the database, or else you can call that person as a non-executive director, because since that section itself is not applicable to you.
Okay, Mr. Bala, your view?
I would agree with Mr. Sanjay Radhi, because you have opted to appoint him as an independent director, in which case all the provisions relating to the independent directors are required to be complied with, really, if you want to call him as an independent director.
Okay, so I will put that way, that independent director per se is a position which is give the indication to public that this director is independent. But if that is indication you give, the act provide compulsorily you will do now. But if you do voluntarily, then you are giving misrepresentation if you don't comply. That is your view.
Correct.
And that's why you have to give, like we are telling for directors.
Diptiban, I differ with Bala Sahab and Sanjay Bhai. Say simply to create a fraud on others. You cannot have that sort of a nomenclature being given to Mr. X or Mr. Y to be an independent director. See, if you give, because you are doing something which is not required, and if you are doing, overdoing also gives a rise to suspicious, and in case of any fraud, any non-compliance, he may not be in a position to get immunity. So basically, if it is not required and then appointed as an independent director, in spite of the fact that he complies everything, but he shall be held responsible for each and everything. He may not get an immunity of an independent director, what otherwise is available in the court of law. While referring our discussions, I was just seeing a case law wherein under section 138 of Negotiable Instrument Act, the person has charged each and everyone. There is an High Court decision of Gujarat High Court squashing that applications being filed against independent directors. So probably into this private limited company, he may not get an exemption of Negotiable Instrument Act that he was an independent director in a private company. He has complied all the provisions and hence he shall not be liable for 138. Probably this is my view.
See, nobody can actually stop me going beyond the requirement of the law and comply with the things. Because here, when you are saying this, as Dipti puts it very clearly, it is the independent position which is created by the law. So in some companies it is mandatory, some companies it is not mandatory. In a non-mandatory company, I want to follow to bring the better corporate governance. Who can stop me? If I decide to do that, I need to comply in the letter and as well as the spirit, the applicable provision for that. I cannot say partially I will comply, I will call them, partially I will not comply. I cannot do that.
Exactly. I agree to it, sir. But as regards the immunity, my answer was with regard to immunity, simply by naming a person as an independent director where it is not mandatorily required, one cannot escape from the lapses what might have been occurred into that company. That is what my view is.
No. Umesh Bhai, in case if I am complying with all the provisions of
Mr.
that
Sanjay,
particular...
1 minute. Mr. Sumit, can you unmute? There is a background noise coming. Mr. Sumit, please mute yourself.
Ma'am, I muted myself.
Yeah.
Yeah. Carry on.
Yeah. So basically what I was saying is that in case if, as Bala sir has mentioned, if you're going beyond your requirement and you are complying, or you are putting some additional, you are taking some additional compliance. So along with that additional compliance, you will get that benefit of additional compliance as well. So if a person has been appointed after complying with all the provisions, then he will get that benefit of immunity as well.
Correct. Absolutely, you are right. Because so long as you are the compliant company, what is actually protection available, that will be available to you.
The next question is definition of independent director has been amended from 1st January, and regulation 25 requires that declaration needs to be provided from independent director that he meets criteria of section 6, regulation 16 1B. Can this be taken at start of financial year 22-23, or we need to take confirmation from independent director as on today's date and place in meeting we held for quarter ended December meeting?
So question, well, can you repeat?
Yeah. They are telling independent director definition is amended from 1st January 22. They need to give declaration as per regulation 16. So what they question is, we will take at the time of start of financial year 22-23, that is April, or we need to take confirmation from independent director today date and place it in a meeting to quarter ended December ending. So that declaration, which is a new requirement, can it be taken? It is effective January. So whether it will be taken in this quarter also, or it will be has to be taken in the starting of the
Both the times, Diptivan, it is always say better to be precautionary and move ahead, and to have the confirmation from them in the first meeting also, to be held in February.
Mr. Rathi?
I would agree with Umesh Bhai.
Okay.
Because the definition has changed with effect from 1st of
1st
January.
January.
Correct.
Okay.
You need to comply with that definition requirement and ensure that there are declarations available.
Second question, at the time of financial institution appoint representative director on board, even when no loan or funding is done by them, a company treats the same as non-executive director and not a...
There is a lot of background disturbance.
I know somebody... okay, I will connect. I'll instead...
Mr. Sumit Sharma, I believe his mic is continuous on.
Yeah. Mr. Sumit, can you switch off?
Yes.
Thank you. At times, financial institution appoint representative director on board of companies even when no loan or funding is done by them. And company treats the same as non-executive director and not nominee director. Is that approach correct? Financial institution holding shares in the company which is less than 10%. So, there is no funding by financial institution. He has they have appointed director. They are taken as non-executive director, and whether this approach is correct.
This approach is okay because it is basically the financial institutions are appointing director here for hello. Financial institution is appointing director for because of their investment in the company and not because of their loan. So the person is appointed even if there is less than 10% of holding, and that can be considered as a non-executive director if we are complying in that manner. The only difference here would be that he would not get the immunity of nominee director in that case.
Okay. Next question. In an unlisted public company, there are 5 directors. 3 executive, 2 independent. the company goes into CRP, RP has been appointed and the board has been suspended 1st January 21, and while filing MGT 7 for the year 31st March 21, how to show the directors as the board has been suspended and MGT 7 does not allow to put information about RP. Whether we can mention about directors who are suspended on 1st January, please focus on this.
See, Diptiban, as regards the CIRP is concerned, the directors do not resign from the board. The only thing difference is that the power of the board is suspended. The directors cannot do any action on their own, but they remain the director. As regards the RP is concerned, on filing of your INC 28, as when the company goes into CIRP, the details of RP are available. RP is available on MCA site. Now the directors' details have to be put in. If they are continuing as an executive director, they will continue as an executive director. No board meetings are held because there are no powers to be given. But the RP can assign a director to sign the forms if at all required. We can ask the directors to sign the balance sheets because the balance sheet may have certain accounting information which are pertaining to their period. But the director's details in MGT 7 has to be put in. At the most, what he can do is the RP can file a declaration along with MGT 7 as an added annexure to it, saying that RP has been appointed. RP has been appointed, and he can put a letter along with that form. That's it.
Okay. I think this Mr. Sumit Sharma is not unmuting it. Okay. Now,
Dipti madam, if you are administrator, you can mute him.
I have already instructed now.
Okay.
Okay. Please, Mr. Dilip has doubt, put the in a chat box. So, in case of appointment of nominee director, consent in DR2 is to be attached. DR12 for appointment or nomination letter is attached. In consent in DR12, in DR12, whether the consent letter will go or consent in DR2, that is the question. In case of nominee.
What I feel is Diptiban, Sanjay Bhai can tell better since he is in a corporate. But there is no assumption that consent, because consent not only includes that he is consenting to become a director, it contains many other information also, wherein he is a director in other companies or whether he is holding shares into other companies. So probably it has to be required that consent is also to be given along with sanction letter. But Sanjay Bhai and Bala
That is required, sir. I agree with you. I agree with you.
And we discuss also that consent is required for nominee director.
I don't have much experience of the corporate, working with corporate as a company secretary. So whenever it comes to corporate, I look forward to Sanjay Bhai and Bala sir, who had formed a very good companies as such. I admire Bala sir since my early days, wherein I was looking forward to him when he was with Postal as to a great company and a great company secretary.
Bala sir is veteran.
Yeah, he's a veteran, Sanjay Bhai, exactly.
Thank you. Thank you.
Next question from Mr. Dilip is too big, so I cannot read and it cannot be worked out with the voice at a time. Next week we will take it. I will brief it and then I will take it that question. Sometimes it's ex officio procedure. In that case, resignation is not possible. I don't know what is the question. Ms. Namita, clarify your question and send it to us. So next time we will take it next week. On a lighter note, I don't have any particular question, but second, the general opinion of government companies having their own law. I am among early registrants on the Prime Director's website, but maybe I am still not that capable to receive one single invoice from home. That is possible.
Dipti Ben, Namita's question I am reading. Sometimes it's an ex officio position. In that case, resignation is not possible. I think probably she is asking that because of any position, say Governor of Gujarat or President of India, because he is the president over there and he is holding the position, say the Falana, the chairman of X and X private X and X corporation will be the whole-time director or would be the chairman of the company. Now, since he vacates that position, his resignation is not possible. Probably the office order can be attached to DIR 12, saying that he was appointed as an ex officio because of the holding his position into so-and-so company as so-and-so position. And hence, say in, I don't know, Bala Sahab or Sanjay Bhai can tell that the company secretary of the corporation shall be the director into this company. Now that company secretary of that corporation has resigned from that parent body, immediately he will vacate the office and another person who is appointed as a company secretary of that corporation will be appointed. So the office order wherein he has resigned or he has vacated the position as an ex officio, that order can be attached with DIR 12 and can be filed along with that resignation instead of resignation.
I agree with you, so Umesh bhai, completely. So in case if there is any ex officio position which is being created in by virtue of the articles of association or by virtue of any statute, so that particular position would continue in that manner, and for any changes in that, even for appointment or resignation, the office order is sufficient.
Yeah, that's right. Agree.
Okay. Next question. Independent directors sitting fees to be paid. Answer is already given. Yes, possible. Pass the resolution by section 197(5), which is aligned under head such other purpose. Rachna, can independent directors who are paid for attending board meeting and committee meeting, can a particular independent director waive receiving sitting fee for a committee? Yeah, for payment of commission of being payable to an independent director, can different rates be paid? Whether director can waive sitting fee, according to me, yes, it can. And whether
Yes.
the commission to be paid to independent director, it can be different percentage for different independent director. Panel.
Yes, it is possible that company can define a policy and directors among themselves can also define. Especially in one of the cases, I have seen that lead independent director have taken a special lead and given a specific ranking to different directors. And based on that ranking, the commission payable to each of the director has been defined.
Yeah, and it is like a performance driven actually. So it's
Yes.
Yeah.
Yeah, in fact, the commission payment is actually made by different companies, different policies, because in some companies, simply they wanted to make a number of days the director is present. In some of the companies, they have the different rate for the independent director, non-executive director. In some of the companies, again, based on the rating they give. It is possible to have the different rate, but only thing is, company need to have the policy framed with them.
Very correct.
I think with this question we'll end. It is 1:30. There are still 40-50 questions. As Umesh Bhai suggested, I will compile this question and we will continue our presentation for the next week on the same topic, though we had another topic of social stock exchange next week. But we'll postpone that and we'll continue this session. Thanks everyone. Thanks Sanjay Bhai. Thanks Umesh Bhai. Thanks Balaji. Thanks Shailesh Bhai.
Thank you.
Anshul and everyone who attended this and all participants. If you have more questions, please send it on the mail. It will be taken next week. Thanks a lot. And
Thanks
have
a lot,
nice time.
everybody. Take care.
Thank you.
Take care.
Thank you very
yourself.
much.
Stay safe.
Thank you very much for.
Dipti Ben, I would like to thank you for bringing all the old good friends together. Shailesh Bhai, Bala Sahab, Sanjay Bhai. Otherwise, it would not have been possible to be on the same platform. into time of this COVID,
Yeah.
it is good to see the faces of our members and the old friends. So thanks to Team Mehta and Mehta for bringing all together.
Any
Thank you.
Umesh bhai will regularly call you and I definitely will bother you. Don't worry.
Well,
Thanks, everybody.
Atul bhai has made last appearance.
No, sir, I was very much here. I was listening to all words. So thank you all. Thank you all.
Thank you.
You both panelists and all four, Shailesh bhai also, you should be available next week. Thanks a lot.
Thank
Yeah.
you.
Yeah. Thank you.
Thank you.
Thank you, Mr. Bala. Thank you.
Thank you.
Bye.
Good day.